There are special planning considerations when it comes to second marriages and blended families. Oftentimes, what we see is that two spouses have two different sets of children, and the concern is that if one of the spouses dies and the survivor receives all of the assets, that they may not treat their stepchildren fairly. They may disinherit them or give more assets to their own biological children. And that's obviously a concern for the parents when they're doing that planning. There's also issues that just come with marriage in general that are in play here as well. So there's something called the elective share, which prevents a spouse from totally disinheriting their survivor. So there's at least 30% that surviving spouse can claim as their own. In addition, they can have what's called a life estate in the primary residence, the homestead, regardless of how it's titled, or a half interest in that home in some circumstances. So it's not just a matter of writing into your will or your trust what you want to have happen. The better approach oftentimes is to have what's called a post-nuptial agreement put into place where both spouses mutually agree that they're going to waive the elective share and other inheritance rights. That can also deal with divorce as well. And then from there, each spouse can decide how they want their assets to pass after they're gone. And do they want things to go directly to that surviving spouse or maybe held in what we call a credit shelter or bypass trust for their benefit, but in a way that is more likely to guarantee some inheritance for their own children? So blended family planning is definitely a difficult aspect, but not insurmountable. And if you have questions along those lines and need some advice, feel free to give us a call and we'll see if we can help.